So I'm just going to introduce Isabel, one of the newest members of 4 New Square. People keep coming, excellent practitioners, which I think really speaks to the strength of the place. Allow me to market us in that way. So Isabel's going to take us to a really good talk on auditors' liability, and I'll pick up on a couple of the points that she's leaving open at the end. And we'll hope to get through it, possibly even with enough time for some questions, but we do appreciate that you've had a long day. So Isabel, over to you.
Yes. Thank you everybody for joining us. In a recent conversation with the Professional Negligence Bar Association, Lord Sumption extolled the virtues of historians who become lawyers. And as one such historian who's become a lawyer, when I was preparing for this talk today, I had started to consider the history of auditing. And allow me, if you will, a small digression. It appears that there were auditors, so-called, in ancient Egypt who supervised the pouring of goods into the pharaoh's house of silver of the treasury. And under the Persian king Darius, whose photo of a relief is on this slide, they were known as royal secretaries and acted as the king's ears and eyes in the satrapies of his empire. And in fact, one was even waylaid and murdered en route to carrying out his duties. But you will no doubt be relieved to hear that we are not wallowing in ancient history today. We're going to bring you bang up to date with auditors' negligence. And we have decided to talk about this particular area for 3 reasons. Firstly, auditors' negligence is often where the most exciting developments in professional negligence law, and indeed tort law more generally, are to be found. To give just 3 examples, we have Lord Denning's dissenting judgment in Candler and Crane, which was obviously approved by the House of Lords in Headley Burn. We have Caparo and Dickman, and more recently, of course, we have Manchester Building Society in Grant Thornton. Secondly, auditors have had several high-profile failures in recent years. For example, PwC and Tesco, Grant Thornton, Patisserie Valerie. And it seems highly likely that more litigation will follow. Thirdly, and despite consideration by the Supreme Court and by the Court of Appeal more recently, this is still a developing area of the law, and that's shown by the regularity with which strikeout applications are made and the frequency with which they fail. Do feel free to come in, by the way, there are some seats there, if you can bear it. Be nicer than standing up for 40 minutes, that's for sure. Now, Paul has very briefly introduced what we're going to talk about, but to give a little bit more flesh on the bones, I'm going to consider the general position in relation to auditors' liability to third parties. I'm then going to examine the court's likely approach to the duty of care in such cases and look at the importance of purpose, knowledge and reliance. And then we're going to look at the first 4 McNaughton criteria before turning to Paul for his excellent analysis of the final 2. So then let's start with the general position. Accountants, like other professionals, owe duties of care to their own clients, but they do not owe them to third parties in the absence of some special factor. And what are the cases that tell us that? Well, as you all know, Caparo and Dickman, which is shown, indicated by the slide with the man at the steelworks, or at least in my head he's at the steelworks. Caparo and Dickman held that no duty is owed to shareholders or investors suffering investment losses as a result of relying on a negligent audit report. Generally, of course, no duty is owed to lenders or creditors, and Al Saudi Bank and Clark Pixley told us that. In that case, no duty of care was found where banks had relied on negligently audited accounts in deciding to advance loans or to advance further loans to the audited company. Now, why is it that the courts have been reluctant to find this duty? Firstly, the purpose of audited accounts is to enable the company's directors or management to make decisions about its management for the benefit of its shareholders, not to assist third parties in relation to their own investment decisions. Secondly, those accounts are widely published and they're read by a large number of potential claimants. So if you have a wide duty of care, there is a real risk of creating liability in an indeterminate amount for an indeterminate time to an indeterminate class, as the New York Court of Appeal warned in Ultramares picked up in Caparo itself. There is also some other potential difficulties. There might be difficulty in obtaining professional indemnity insurance for such claims if they were to face claims from a wide range of parties. And that is in fact one of the factors picked up in Caparo by Lord Oliver. And linked to this, perhaps, is the effect it would have on accountants and auditors' fees and the possibility of a decrease in competition and a reduction in standards, and that was picked up in the Australian case of Asander and Pete Marwick. There also is perhaps an inherent unfairness in allowing third parties to benefit from advice and information for which they have not paid. And again, that's one of the reasons the court gave in Asander for declining a duty of care in that case. But that is, of course, not to say that auditors never owe a duty to third parties. So how might a court approach a duty of care in such a case? The search for what Lord Toulson, in the case of Michael, termed a universal formula or yardstick as to whether a duty of care and negligence exists has, he noted, been elusive. And as the author of Chapter 1 of Simpson, and having to wrestle with this problem annually, it is a problem with which I would like the Supreme Court to be a little clearer if they could. Because it's fair to say that their position in the flurry of cases in the 2010s and thereafter has perhaps not been as clear as we would like it to be. And so today it's with some trepidation that I propose a potential way forward in such a claim. In my view, the likely position in relation to whether auditors owe a duty of care to third parties is this. The starting point, as indicated by the longest arrow on the slide, is that a claim for negligent misrepresentation is likely to be the consideration of the assumption of responsibility test, and that's laid out in the case of NRAM. The court's going to consider whether or not there is an existing analogous case. But if there is a sufficiently compelling analogous case, it might require cautious incremental development in order to fit, Lord Wilson said, in order to fit cases to which it does not readily apply. So we see a small amount of incrementalism there. But we also know that incrementalism is going to be key in relation to novel cases, and Robinson made that clear. In novel cases, the court will consider the Caparo factors. For many years, perhaps, we thought that was a test. We've been told we were wrong. It's not a test. It's, in fact, a categorisation of factors relevant to the recognition of the duty of care, that is to say, foreseeability, proximity, and fairness, justice, and reasonableness. And novel claims have been considered again in the case of Benyatov and Credit Suisse. Now, that concerned whether an investment bank owed any duty of care to protect an employee from the risk of criminal conviction and consequential losses as a result of him performing his duties. And the claimant alleged that the starting point was the assumption of responsibility, but the court said no. The court said in novel cases, the correct course was to take the incremental approach, which will in principle involve consideration of the Caparo factors. And as to assumption of responsibility in novel claims, Lord Justice Underhill reduced it to a useful analytical tool, and he even said its usefulness will depend on the issues in the particular case. So therefore, one can see that the significance of incrementalism and the significance of previous cases and analogies to be drawn from them is really key. The reality is, of course, as we all know, that if you were to get one of these cases, the legal team is going to explore all different angles, and they're going to look at all the different ways that you might apply the duty of care test and see what answer you get as a result. But nonetheless, and despite being an associate editor of Simpson, the key in this case, in a 4 New Square Day, is of course Jackson and Powell. And Jackson and Powell make it abundantly clear is that we are not to lose sight of the following factors: the purpose for which the statement was made and communicated, the knowledge of the maker of the statement, and reliance by its recipient. And also of importance, and I've put at the bottom of the slide there, is the existence of disclaimers. But luckily for me, Paul is dealing with that later. That these are significant factors is key from Caparo itself, and I've set out the references on the slide. It's also clear that these are important from the McNaughton criteria developed by Lord Justice Neal in the case of McNaughton and Hicks, and also, as he later was, Sir Brian Neal in BCCI and Pricewaterhouse No. 2. Now, perhaps unhelpfully, the two lists that he developed are subtly different. So for our own clarity, in this case, I'm going to focus on the 6 McNaughton factors. I'm also really pleased that the drilling has just started. So, anyway, ignoring that for the moment, the McNaughton criteria. I've set them out on the slide. I won't read them now because we're going through them, but he set out 6 very useful factors to bear in mind whenever you're considering one of these cases. So let's consider the first case. The first factor, the purpose for which the statement was made. Now, where a document is an auditor's certificate in relation to a company audit and there is no indication as to its purpose, the court is likely to conclude it was made merely for statutory purposes of giving information to the shareholders as a body, as in Caparo. But where, however, a statement is made for the express purpose of communicating it to the third party, then a duty of care might arise. And there is a really helpful case which illustrates this distinction very neatly, and that is ADT Limited and BDO Binder. And that concerned whether auditors owed a duty of care to a takeover bidder. So the auditors had prepared audited accounts for their statutory purpose, but the auditor was also called to a meeting with the potential purchaser at short notice, the purpose of which was explained to him only in the most general of terms. And at that meeting, he was asked the simple question of whether the company accounts were accounts on which the purchaser could rely. And Mr. Justice May, as he then was, notes in the reported judgment at page 834, Mr. Bishop did not have to say yes. He could have declined to answer. He could have given a disclaimer, that word again. He could have said that if ADT were to rely on his answers, he would need to take advice. He could have said words to the effect, yes, I do stand by the accounts, but this was a difficult audit because. Rather than doing any of these, he undertook to answer the question posed and gave an unqualified favourable answer. The court held that the auditors in that case did owe a duty of care to the purchasers of the company. They held that the representations made by the auditor was made for the purposes of providing the takeover bidder with information upon which he could rely without further inquiry. But these distinctions are based on extremely fine analysis, and for an example going the other way, see Peach Publishing and Slater. So in that case, the claimant was proposing to buy the share capital of a company called ASA. The claimant's representative, Mrs. Land, said she wasn't going to buy it unless the seller gave a warranty as to the accuracy of certain management accounts. Now, the seller wouldn't give that warranty without asking the accountant, who is both his personal accountant and the company's auditor. And at a meeting, Mrs. Land pressed the defendant to give his approval, which he did. After the purchase, predictably, it emerged that the accounts were inaccurate and the buyer sued the accountant. But the Court of Appeal held, overturning the first instance decision, that although the accountant's assurance had been given both voluntarily and directly to the claimant's representative, the purpose of the assurance had been to advise the seller that he could give the warranty, and he had not assumed any duty of care to the claimant directly. Now, at first glance, that just seems odd. Those two decisions seem to be completely distinct from one another. But it's worth noting that in Peach Publishing, the claimant had no faith in the defendant accountant whatsoever. After one meeting with him, she wrote an aide memoir, and the Court of Appeal commented, "It is plain from this document that she believed him to be thoroughly incompetent, indecisive, over-compliant and slow." And later on, they made the point that it was inconceivable she would have committed the claimant in reliance on anything produced by the defendant. The claimant had wanted a warranty from the vendor, not from the auditor. What then about the second factor, the purpose for which the statement was communicated? Here we're really looking at the question of, was the statement communicated for information only or that some action could be taken? An example of the latter is the case of Andrew and Kunis Freeman, which, as you can imagine, involves flying, hence the picture of the plane. So here the audited company was the Flight Company UK plc, which I shall call the operator, and it needed to apply to the Civil Aviation Authority, the authority, in order to renew its air travel organiser's licence. As part of this, it needed to submit accounts prepared by its accountants. The authority refused to accept the draft accounts. They sent a letter to the operator setting out its requirements for the grant of a renewal of its licence, which included audited accounts. The defendant auditors sent a copy of the audited accounts to the authority, referring to the authority's own letter. The authority renewed the licence, and again, predictably, the operator collapsed. And the authority and a trust on its behalf had to arrange for repatriation of a large number of stranded passengers, which cost about £6 million. And so they decided to sue the auditor. The Court of Appeal held that the claim ought not to have been struck out at first instance. They said it was arguable that reasonable auditors in the position of the defendants would have known the following. The financial position of the operator was a matter of importance to the authority in considering whether to grant the licence. The authority would have taken the accounts to have been prepared with due care and skill, and there had been no reasonable opportunity of any independent evaluation of them. It had all happened very quickly. What then about the relationship between the third party and the auditor? So Brian Neal in BCCI number 2 pointed out it could be a general relationship, or maybe it sprung up specifically as a result of a particular transaction, but you need to look at it. And the other thing you need to look at is where the information or advice has been prepared for party A, rather than the third parties actually relying on it, is that third party going to look at party A and through them look at the auditor themselves? And an example of where this happened is Siddle and Smith Cooper. There the claimants had a number of hats on. They were directors, they were shareholders, and also they had borrowed money in order to finance the company on the security of guarantees from the claimants themselves. And there was also said to be a contract between the defendant auditors and the claimants. The defendants were the company auditors and its accountants, and they advised the claimants at one point to repay some of the company's loans personally, borrowing against the security of their own homes. The company then went into receivership, and the claimants sought to recover from the defendants. The Court of Appeal refused to strike out the claimant's claim. The three factors they looked at in particular were that they were not just auditors, they were the company's accountants providing quarterly management accounts. Secondly, the defendants had been requested to and did give advice as to how to refinance the company's borrowings and what personal security they should give. And thirdly, they noted there was a contract between the defendants and the claimants. And viewed with this lens, it seems to me that's a perfectly understandable decision. Everything was obviously very interwoven with this particular case. And it's also the case with BCCI number 2, which again at first glance seems odd because the auditors were responsible for two companies, Holdings and SA, but they weren't responsible for another company overseas. That was audited by someone completely different. However, the Court of Appeal found that in essence they had been operated as a single bank. And Sir Brian Neal described this beautifully in saying that the defendant auditors on the one hand and overseas auditors on the other, the difference between them was a mere shadow, which is a very beautiful way of putting it, but it's quite useful to remember. So what Sir Brian Neal held was that in cases where parties are dealing at arm's length, the court is slow to extend the orbit of the duty of care to anyone other than the immediate client. There was a barrier that had to be overcome, but they were prepared on the facts of that case to do so. In relation to my factors then, this is my final one, and it's much simpler than some of the factors we've been looking at. A duty of care can arise, as we know, where a statement is communicated to a class of people, and that's made clear in Caparo. The smaller the class is, the more likely a duty of care will arise. And the reason for that is there are much less powerful policy arguments about unlimited liability to an unlimited number of people, etc. But this is a necessary but not sufficient factor. So in Al Saudi Bank, which I mentioned at the beginning of the talk, that concerned claims by lenders. The lenders fell into two kinds, those that lent for the first time on the strength of the negligently audited accounts, and those that lent again. They'd already lent before and they lent again on the strength of those audited accounts. And in relation to that latter smaller group, Mr. Justice Millett held that it was not sufficient that they were members of a smaller and limited class of existing lenders who were known to the defendant auditors, in the absence of evidence of knowledge on the defendant's part that their report would be shown to these lenders. You needed something more. The High Court of Australia has rejected a claim that a duty of care was owed to a class consisting of the creditors of a company in Asander Finance and Peak Mawick, and I would tentatively suggest it is likely the court will come to a similar conclusion here. So pausing as the drilling dies down for a moment, let me bring these threads together and to try and offer you some conclusions in relation to the four factors that I've been looking at. In my view, the central factual inquiry is likely to be focused on the following areas. Firstly, whether the primary purpose of the statement was for the statutory purpose of giving information to the shareholders as a body, or, conversely, did the defendant step outside the normal role of an auditor? Secondly, have there been any direct dealings or communications between the third party and the auditors? Is there some sort of relationship between them? Thirdly, have the defendant auditors given explicit or even implicit consent for the claimant's relevant reliance on the defendant's statement? And finally, what are the circumstances in which the statement came to the notice of the claimant? Was the claimant part of a large or indefinite class or some sort of identifiable smaller group? Over to you, Paul. The drilling's back for you. There you go.
Thank you very much, Isabel. I really like having many, many cases all put into one little document which can then be taken home afterwards. It's really helpful. So look, I'm going to look at the next bit, which is the knowledge and the knowledge of the defendant and the reliance of the claimant. But how does this all fit together? So these are torts about the damage caused by words. Right? How is it that one is liable to the other? It's because someone said something or written something, and then somebody else has relied on it and suffered a loss. So it's conceptually much harder to deal with than damage caused by a car or a fist or whatever. And in that context, the role of knowledge is absolutely central, the knowledge of both parties of certain things. And this is what we are going to look at in this part of the talk. So in McNaughton, Lord Justice Neal described the defendant's state of knowledge of the use that his statement would be put to as one of the most important matters to examine, which is right. And to found a duty of care, this knowledge, as we have heard, must be in relation to a transaction, or at least a type of transaction, that the defendant knows about. And he must also know, or ought to be able to work out, that the statement or advice that he's about to give is going to be relied upon. And it's that knowledge that transforms his word into a deadly weapon, because he's giving it so that you do something, and he knows that's what's going to happen. Now this, I think I may have gone through two slides there, sorry about that. So a good analysis of all this is Caparo itself, where the point is made that the salient feature of all these cases is that the defendant giving advice or information was fully aware of the nature of the transaction which the plaintiff had in contemplation, and knew that this advice or information would be communicated to him directly or indirectly. So that's the source of all this. It's up there, you don't need to necessarily read it all now. But to express this in the sort of terms of our building blocks for does a duty of care exist or not, if you put it in terms of assumption of responsibility, this knowledge requirement goes to the question, has there been a voluntary assumption of responsibility by the defendant? Because if he knows these things, then it could be said that he has volunteered to take responsibility for them. But if you want to use the other kind of analytical metric, which we're not supposed to use as much, the threefold not test, then the existence of knowledge goes to foreseeability, because if you know that someone might rely on it, it's obviously foreseeable that there might be a problem. It goes to proximity, because if you know that someone's about to rely on you, you're bringing yourself into a close relationship with them. And it also goes to whether it is fair, just and reasonable to recognise the duty at all. So it's the knowledge that really matters. And obviously, most of the rest of this part of the talk is about the application of those simple principles, as it usually is. But the centrality of this knowledge requirement explains the particular conceptual effectiveness of an auditor's disclaimer. Because if there is a disclaimer, it goes a very long way to answering the question, has the defendant voluntarily assumed responsibility? So you can know perfectly well that somebody might want to rely on his statements. But if he says, well, look, I don't permit you to rely on my statements, I'm making them for another purpose, I know you might, but if you do, it's not on me, it's on you. It's making very, very clear that as far as he's concerned, he's not intending this person to rely on what he says. Now, some might say, well, this is rather tricky, because if you know someone's going to rely on what you say, if you actually know that's what they're going to do, can you really just walk away from the catastrophe by the mere business of saying, I don't accept any responsibility to you? And the answer is not really. I mean, it has to be focused, as we will see in the case which we'll look at later. But the court is going to be assessing also not just what the defendant knew, but what the claimant knew. And the court is going to be looking at the claimant and saying, well, would a reasonable person in the position of the claimant in this case have relied upon, the words which matter here in circumstances where the generator of those words is saying, don't rely on me, make your own choices. And this is where you get into the question, well, is it actually reasonable to rely on the words complained of in circumstances where there is a disclaimer? And the basis for these propositions I've just been making is in those two authorities, which you can read those quotes for yourself in due course. So the disclaimers which tend to be given by auditors, I see the front row here perking up, is this one, the Bannerman disclaimer. So this was a celebrated case in Scotland where the Royal Bank of Scotland sued Bannerman Johnston Macleay and made observations about the absence of a disclaimer, which prompted the ICAEW to draft a form of disclaimer which sets out why are we giving this, why are we making these statements, the statements being the audited accounts. Well, we're doing it to report to the company's members as a body, not individually, vitally important, And we're fulfilling a statutory responsibility, and we've done this so that we can state to the company's members those matters we're required to state to them and for no other purpose. And so for the avoidance of doubt, we are really not going to accept responsibility to anybody else who happens to get hold of this document and read it and make a decision. Now that is a perfectly fair disclaimer. I mean, it's been examined in Barclays Bank and Grant Thornton by Mr. Justice Cook, and he thought that it was effective. Now, I'm going to give a little digression on disclaimers, which will help open the door to the case we're going to look at. They are not contractual exclusion clauses, because there isn't a contract, obviously, between the person relying on the words in question and the person who made the statement. But they are notices. And as such, they are capable of being assessed for reasonableness. If it's two commercial parties under the Unfair Contract Terms Act, and worse still, if one of those parties is a consumer, then under the Consumer Rights Act. Now, those of you who know the Consumer Rights Act will know that it's incredibly effective at protecting consumers from perfectly ordinary drafting, which in other contexts would not be objectionable at all. Is this ever going to be relevant? Maybe, actually, because if you think about the circumstances where consumers drift into the world of looking at audited accounts, I mean, the ideas that occurred to me are, what about family members lending capital to a company owned by another family member? The auditors know about all this. Maybe. What about people who inherit shares, executors who end up with ownership of shares and have to take some step as part of the administration of the estate and end up relying on something said in the accounts? So I don't think it's the case that just because there is a disclaimer, if you can find a way of treating if you're a client as a consumer, there may be some answer. But an important thing to bear in mind is that at the point where an auditor makes the disclaimer, so in the audit report, that's the moment at which the disclaimer is kind of taking effect. Here is my report on the audited accounts. Within this piece of paper, there's representations made by me to the members of the company, and I don't accept responsibility to anybody except them. But what happens if the auditor then takes those accounts and does something else with them in some other context? So he or she themselves takes the accounts and starts to make representations about them. Can the disclaimer that says, I, creator of these accounts, accept no responsibility for anything to anybody, save as set out in my Bannerman disclaimer, can the actions that they take after that point bring about liability in any event, or does the disclaimer act as a kind of shield? I think you can tell by the way I framed the question what the answer is going to be here. So this recent case was a judgment by Master Brightwell, Amathus Drinks and EAGK, is factually interesting and does illustrate our point. So I've set out the broad bit so you can keep hold of it whilst I talk, the basic fact pattern, but in a little more detail. So in August 2015, the claimant company entered a share purchase agreement with the existing shareholders of a company called Bablake Wines Limited to acquire the entire share capital. So far, so standard. And the claimant was assisted in negotiating the terms of the SPA by a Mr. Christoffi, who was a partner in EAGK. So there's the beginning of the commercial relationship between the claimant and the person who became the defendant. The consideration payable under the SPA was calculated by a formula provided in the SPA, as is usually the case. And a critical part of this mechanism for calculating the consideration was the preparation of completion accounts in the usual way. And the accounting period of the completion accounts was different to the statutory accounting period. So it was a bespoke period of time. And a term of the SPA was that the sellers would convene a completion board meeting and they would appoint EAGK as the company's auditors and accountants for the purposes of preparing, among other things, the completion accounts. So you see the way the relationship is working. You've got the buyer with their accountants on board. They insert their accountants into the vendor's company, or the shareholder, the seller's company. And they say, right, now our guys, as it were, are going to prepare your final accounts. This will be good for us because we trust our guys, is the background unsaid thinking. So there's a retainer letter in which EAGK write to, correctly and properly, the company. And they say, thank you for retaining us to prepare these accounts. We will do so, and we'll do it on the terms of the Bannerman disclaimer. We'll be preparing the accounts for the current members. So the current members are, of course, the vendors. The accounts are prepared. And there they are. Now, before we go on to what was wrong, you can just assume, can't you, that the accounts unfortunately missed a major fraud, which resulted in the consideration payable under the SPA being a great deal more than it would have been had that fraud been taken into account. So those audited accounts were sent out in April 2016, and then in September 2016, the completion certificate, which is the trigger for payment of the consideration, was generated by EAGK. And the completion certificate arose from, of course, those accounts, the April 16 accounts. And the completion certificate was addressed to the sellers, the former shareholders of Bablake Wines, and to the vendors, the purchasers of Bablake Wines. So the completion certificate, you will have noticed, was not addressed to the company. It was addressed to the former owners and the current owners. And it just said this is the price payable. So when the fraud emerged and was uncovered, the buyers sued EAGK and they said, you owed us a duty of care. In fact, it seems that in the first iteration of their pleadings, they were a bit vague in the allegations that they'd made, and the master made them go away. And when they came back, they had a quite neat case actually worked out on how a duty of care arose. So they said, first of all, well, you owed us a duty in contract as a kind of implied party to the retainer, because it was in the SPA said the company has to appoint you. Somehow you owed us a duty, and the master just said, no, that doesn't work. That just doesn't work. So we don't need to worry too much about the contract. But the claim in tort, it was accepted by EAGK that if the disclaimer had not been present, maybe a duty of care would be owed. But they said, but there is a disclaimer. And we obviously were just relying on the completion accounts when we provided the completion certificate. It's the same thing, and we're covered by this disclaimer. So they were seeking to use their shield to protect themselves against any complaints made arising from the completion certificate. And so they said, that's it, we're out, we're off. You can't possibly have relied on us because of that. And the master refused to strike out the claim, saying that it had been pleaded, quite interestingly, that during the auditing process, so before April 16, Mr. Christophe, you will recall the advisor who had helped negotiate the SPA, had been sending emails to the claimant, not copying in the defendant, in which he'd made some comments about the state of the auditing process. And the master said that it was arguable that Mr. Christophe was still treating himself basically as part of team claimant, because he'd been their guy to help negotiate the purchase, and he was still holding himself out as their guy, which might have brought into being a separate assumption of responsibility or duty of care out with the formal auditing process. yeah, I see some raised eyebrows, but this is arguable. It hasn't obviously been to trial, it just hasn't been struck out. And he also said that the allegations of breach of duty relating to the completion certificate themselves, these were communications from the defendant to the claimant which did not have the disclaimer in them, not formally. And they were, I mean, the completion certificate was clearly something which the defendant intended the claimant to rely upon, because the idea was, here's how much you have to pay, I have certificated it. You couldn't have a clearer example of intended reliance. So is it really the case that you can say, well, look, I did a terrible job on the audit, but there's no duty of care there. However, in good faith, I relied on my terrible earlier job, and here's how much you need to pay. And so the analysis was that, factually speaking, that disclaimer arguably didn't bite to forgive any breach of duty. I mean, if you put it in the terms of that quote from Caparo, the defendant could arguably be expected specifically to anticipate that the claimant would rely on the advice contained in the completion certificate. And the claimant would reasonably believe that he was entitled to rely on that certificate. You would, wouldn't you? And the effect of the disclaimer has effectively had been negatived entirely by the fact that it wasn't present in the certificate. So it's floating around in the background like a piece of loose DNA, but completely ineffective. Now, it will be interesting to see what happens at the trial and what further facts emerge. I mean, just interesting generally as a matter of gossip, because it'd be interesting to see what happens about Mr. Christophi's relationship and these emails that were happening during the audit, because it is quite conceptually gripping, this notion that you can be performing an audit for the benefit of the members of the company only, covered by a disclaimer which everybody knows about, and then stepping outside of your auditing role to give a report to somebody who knows perfectly well that you're preparing the audit for the members of the company only. Does that telephone conversation in which you make a few remarks about the audit bring into being another separate duty, a sort of parallel auditing duty? Or is it just words from the coalface covered by the effect of the disclaimer? Who knows, we will see. So, following Isabel's kind of short points of wrapping up, these are mine on those last 5 and 6 bits of the judgment. The knowledge of both the third party and the auditor are essential elements of whether there has been an actionable assumption of responsibility by the auditor. And both parties have to be found to have known that the third party is relying on the auditor. So that the auditor has to know the third party is going to rely on him, and the third party has to reasonably understand that it's okay to rely on what the auditor said. That reliance must be reasonable. Pretty simple. And a disclaimer is not a magic shield, because it really depends on the context in which it has been given. And just because it's on the back of an audit report doesn't mean that it's going to work, rather as in that ADT and BDO case, which Isabel mentioned earlier on. And that is all I have to say on this topic for now. And I think, look at that, 5 minutes early, just time for some questions from the floor to Isabel.
Yes.
Just a very quick question. You said that this case... Sorry, you said that this case was a strikeout application. Is the case still live, or has it since settled?
I don't know.
I don't know.
No.
It's still live.
Yeah.
So we could get a completely different decision.
We could.
Yeah.
We could.
That's the interesting thing about this area, is you think you know what the ground is, and then it shifts when the final decision is taken. Sorry, yes.
The auditors were reliant, I think, on the standard form Bannerman disclaimer.
Mm-hmm.
The outcome could have been quite different if Mr. Christophi had recognised the risk of him assuming a duty to the buyer. So presumably, if in those circumstances he had put out a specific disclaimer the outcome could have been quite different.
Definitely, and I think we get that from the judgment in relation to ADT and binder, where the judge goes through the options available to an auditor who's put on the spot, who doesn't want to go that extra step. And in fact, the judge lists out different ways in which you could get round it. And I know I have had clients who have given Bannerman disclaimers orally on telephone calls, for example, with a purchaser or the purchaser's lawyers who are looking into that particular company. And so they are aware it's out there. So I think people are using it more frequently than perhaps they were. But yeah, I agree with you, totally.
Although, may I say that in circumstances where this auditor is providing the completion certificate, it might be quite difficult to disclaim all liability, because it's not just the audited accounts which have given rise to a duty. I mean, they're being paid by somebody as part of the process of buying the company. So maybe there is a commercial unreasonableness.
I find the rejection of the contractual case in that slightly odd, because you can have cases where you're only brought in to do the share valuation, and then you would owe a duty to both sides to do that valuation fairly, because you can't owe a duty to one side. So one could see that if you'd done the valuation completely negligently, the other party, as it were, could sue you, and no disclaimer is necessarily going to get you out of that, because that's your job, that's what you've been asked to do. Or at least you wouldn't get paid to do it if you were just going to disclaim all responsibility. So it's interesting area. I'm very impressed. We've had 2 questions at the end of a very long day. Yeah. Well done, everybody. And now I think we are the only thing. Oh, sorry, did you have another question? No? Are you sure? Well, Paul and I are available. Oh, yes.
Can I ask quick, the consumer point you mentioned, surely to be a consumer you have to buy a service, whereas, I mean, under consumer law you have to, I would imagine you'd have to be a buyer of the service, but only a company would pay for an audit. So I was just curious, can a consumer in that context be someone who just doesn't actually buy anything?
Well, so the protection that consumers get is not just against contractual clauses excluding liability, it's also against notices which purport to exclude the liability that might otherwise arise. So, I mean...
But if you're not, it's more the definition of a consumer, like as in, agreed that, but how could you be a consumer within the definition of the 2015 Act if you're not actually buying anything?
Well, for example, if you were taking a, you were investing in a company, or you were buying a proportion of it, or loaning it a little bit of money, but really from your own cash, you don't have your own company, you would be a consumer potentially in those circumstances.
A consumer of the...
Of the services provided by the auditor. So say, for example, if you wanted to, loan the company a small amount of money, and you phoned up the auditor and said, look, can you just tell me, can I rely on the most recent accounts that are up in company's house? And the auditor doesn't disclaim any liability and says, yes, certainly, that's fine. You may well be a consumer in that regard against the auditor. Potentially.
I've not researched the point.
Yeah.
I was just generally
No,
curious,
I think it could be, there could be circumstances out there, particularly now with all the weird and wonderful financial schemes there are and the ways in which you can loan monies to companies. I think it's perfectly feasible. So I'll have to watch this space, see whether it works.
I view the consumer, having recently had a case where I didn't do very well in the face of the Consumer Rights Act, in relation to which I have to say the Court of Appeal only 2 days ago gave permission to appeal on all grounds, just in case any of you have been following that with interest. But I view the Consumer Rights Act as a dangerous, excellent thing to protect consumers, and a dangerous thing when representing defendant professionals. Anyway, are there any more questions from our deeply engaged audience? No? Super. Thank you so much for coming.